Okay, everyone, I promised my colleagues in the courtyard I'll keep this to record time. Now, I know that promise is not legally binding because there's no consideration for it, but I will try my best to honor it nevertheless. So really what I'm doing is touching on kind of a subtopic that I dealt with on Tuesday. We spoke about how maritime contracts can try to achieve decarbonization in shipping through the use of climate clauses. And I spoke about how green norms in contract law would go a long way to make this process more easy. So what is a green norm? Why am I focusing on the concept of norms? Are soft norms really all that important in contract law? Well, marketing literature as well as economic science would tell us that yes, norms are very important. In times of uncertainty, we need norms to guide contractual performance, particularly in an industry like shipping, where we have regulatory uncertainty and climate risks. Shipping actors require a normative framework that is going to guide cooperative contractual performance for decarbonization targets. And marketing science and economic literature tells us that in times of uncertainty, these norms are particularly important, whereas norms become more redundant in times of stability. So I'm focusing particularly on Charterparties, trying to analyze whether there are any green norms in chartering and how do we establish new green norms if we don't have any. So I'll very quickly touch on whether the existing regime has any green or environmental norms, so to speak. If it doesn't, and I think we can all guess the answer, that there probably aren't green norms in chartering, how can we establish new norms? And how can private lead the way in doing this? And how can private actors achieve these green norms? And then I'm going to talk about the importance of taking up green clauses in contracts and how the uptake of green clauses can contribute to a bottom-up normative framework. So first of all, do we have any green norms within the existing regime? Well, the existing regime is governed by the common law. And no, the answer is we don't have any green norms in English common law, which is the law of choice for most international commercial transactions. We have implied undertakings in the common law, and none of them deal with an environmental report. Although we know that environmental factors must necessarily be considered in certain undertakings within the regime. So, for example, seaworthiness must consider environmental certification. And we then also have the regimes governing contracts of carriage. Now, these are not normally applicable to charter parties unless incorporated by a clause paramount. But upon looking at them, none of them really consider green norms or environmental principles either. The Rotterdam rules perhaps goes the furthest by saying that certain deviations can be justified if reasonable measures are taken to protect the marine environment. But that is really the only mention we have of an environmental goal in any of those international rules that apply to the contracts of carriage. So this lack of green norms within contracts of carriage and chartering more generally has caught academics such as Professor Expesso and the Norwegian Maritime Committee to re-incorporate green norms at an EU level, or to read the Rotterdam rules through a green lens, if possible. So that's what some of that academic work is centering on. So if we don't have green norms, and there's this academic call for them, well, where might they come from? We know they can come from international conventions and binding rules. This would be an ideal situation, if we could have these top-down green norms that governments were willing to regulate contracts, which we know they're not always that willing to do. And perhaps if we had an act of parliament called the Green Contracts Act, that would be wonderful, but it's unlikely to happen. We're likely to see this top-down. Now, there's some exploration being done with constitutional principles. So in some, particularly post-colonial constitutions that enshrine a right to a healthy environment, which incorporates reflexive understandings of sustainable development and greenness, we're seeing that perhaps there's the potential for horizontal application of environmental rights, or at least the indirect application that would see us interpret private law obligations through a green prism or through the prism of an environmental right. We also know that environmental norms come from illegality of contracts. So there are parameters that a contract can be exercised within or performed within. And we know that Marple does a good job of making sure that shipping actors do not do things that are illegal. They do not do things that are contrary to international law or domestic law. And shipping associations have drafted material compliance clauses to that effect. But the third, and probably the least spoken about source of norm creation, is the law of standard agreements. And standard form agreements are, generally speaking, the most important instrument nowadays for norm creation in business. And we've seen some examples where these shipping associations have started to use this idea of environmental principles in standard form agreements. The RecycleCon is a really, really good example. Sorry, because the whole standard form agreements of the RecycleCon is aimed towards environmentally friendly and sound recycling processes. Sorry. So how can private actors drive green norms in contracts? We've spoken about this law of standard form agreements, where we can see green norms starting to emerge in certain contractual clauses. Well, the simple answer is that private actors can start to use green clauses. We've spoken about climate clauses and their increasing prevalence, but the obvious solution would be to see a prevalence of green clauses in contracts. Because if private actors decide to use these clauses, and there's good incentives for them to do so, some of which we have discussed on Tuesday, but if they do so, they essentially give hard legal effect to green norms in the absence of an international maritime convention that imposes green cooperative values between ship owners and charterers in contracting. So we'd like to see a prevalence of climate and green clauses in chartering to drive this from the bottom up. And this is already happening. It's not just wishful thinking. It's not just a pipe dream. Actors are increasingly committing themselves to voluntary initiatives and using climate clauses to come over the problem of split incentives. The Chancery Lane project, as I spoke about on Tuesday, has drafted 4 clauses to this effect, which really give us very comprehensive mechanisms for interpreting a contract in a green way, because they don't just consist of boilerplate add-on clauses. They really do give us a number of tools to green the contract as a whole that will guide interpretation of the obligations therein. So there's immense value in taking up these green clauses, particularly the Chancery Lane's climate clauses that are so comprehensive. They consist of recitals, warranties, conditions, a number of obligations that can permeate their entire agreements. Now, first of all, climate clauses or green clauses are very useful when it comes to contractual interpretation and the construction of other express terms in the contract. So the courts have recognized that even when contracts are professionally drawn, there sometimes are conflicting aims, failures of communications, or different drafting practices, different deadlines perhaps that parties might need to reach. In this case, where there is ambiguity as to an obligation, we need a factual matrix within to interpret this ambiguity and to find out, well, what does this clause mean and what was the intention of the parties? What was their objective intention, so to speak? And the courts look to the factual matrix that the contract operates in to give meaning to that term. So if we have climate clauses in our contract, we can arguably interpret other terms in a green way if they are ambiguous as to performance. So by stating it as an objective in the contract, it becomes admissible evidence as an objective fact and is elevated beyond the mere pre-negotiation positions of either party. It also has immense importance for implied terms. So eventually, it would be fantastic if we could imply green undertakings into charter parties by mere fact that these are charter parties and they are a category of contracts. But at the moment, we are not quite there yet. Okay, so what we'd like to see is the elevation of green principles to legal norms and customs, providing a strong basis for the implication of terms. Now, if green clauses are used by private parties, or private parties have adopted certain voluntary green frameworks, or they've advertised their ESG commitments, if they've advertised their CSR, perhaps that is all part of the factual matrix that we might be able to use, which then can assist us with the implication of undertakings where the contract is silent. Now, Hutton and Warren says it has been long been settled that in commercial transactions, extrinsic evidence of custom and usage is admissible to annex incidents to written contracts on matters on which they are silent. And then Lady Hare told us that there's two ways you can do this. You can imply undertakings by way of law. So these are undertakings or terms you can imply into a contract because of the category or type of contract it is, like an employment contract. What we'd like to see is green terms being applied into charter parties because they are charter parties as a category of contract. But we're not there yet. Our best bet at this point is perhaps pushing for implication by fact. So we can do this by satisfying an efficient bystander test, saying, well, it's so obvious it goes without saying. Even if the contract is silent on this point, it's so obvious that no one needed to say it, the parties are in agreement, or we apply business efficacy tests. So what makes the most commercial common sense? Unfortunately, the standard is the one of business efficacy, not necessarily one of environmental sustainability. But if parties start using green clauses in a creative way, if they start making it known in the recitals to their contracts that they've committed themselves to certain voluntary obligations, we have real evidence here which can support implication by fact. Also, enforcement, a green norm might actually see us push the boundaries of contract law a bit. It can help us interpret what a legitimate interest means in new and creative ways. So at the moment, we can only use liquidated damages clauses in contracts. If it does not impose a detriment, which is out of all proportion, and the detriment needs to be compared with a legitimate interest of the aggrieved party in enforcing the contract. Now, a legitimate interest is only interpreted as a commercial interest. So what if we were to interpret this as an environmental sustainability interest? What if we can say, well, the parties have an interest, perhaps one that even coincides and overlaps with the commercial interest. But if the parties have an interest in being green, could we justify enforcement mechanisms such as green damages clauses? And we know that from the case of Parking Eye, a Supreme Court case in the UK, the Supreme Court has given contracting parties a much greater level of freedom in setting damages amounts to be payable upon breach of contract. So perhaps we can say at this point, well, if there's an interest in going green for commercial reasons, whether that be with ESG commitments or whether that be some voluntary framework you advertise yourself as being part of, perhaps then we can justify things such as liquidated damages on a green basis. So green law can really open up enforcement mechanisms in a helpful way. So moving on to conclusions and further remarks. Well, practically, green norms can create a shift in values. And these need to inform how lawyers and law firms conduct themselves and view their role in and impact on society and the environment. So there's a call here for lawyers to start drafting such clauses or using template clauses where available that have agreed reports. So there really is here a potential for a bottom-up normative cooperative framework for contractual performance. We know that green and climate clauses can contribute to this norm creation through using the power of the law of standard forms and clauses. So there's a call here not only for lawyers, but for shipping associations that draft the standard form agreements. And we want to see an elevation of greenness as a principle for shipping more generally. So this would go a long way in helping us green our contractual performance. But the challenge for lawyers, I think at this point, will be to persuade clients that there are real benefits to the use of such clauses, although clients are beginning to see the benefits of going green for a number of reasons. Not only financial reasons for accessing green financing, but also reputational reasons. Very, very strong reputational reasons as well as consumer demand, as well as just being part of sustainable supply chains, green labeling. All of this is very important, and hopefully, in time with the uptake of green clauses, we will see this kind of variation of the contract law regime It is an ambitious target, but I think the work has already started and we just need to spur it on. We just need to keep the flame burning. So that's pretty much what I want to leave you with. I hope I didn't take too long. I think I was well under half an hour.
Oh, that's superb, actually. Thank you. I saw, of course, when I saw you mentioned salvage, I was excited.
Yeah.
Can you go back to that slide? I'm just wondering what you mean by standard form, creating new norms, especially with salvage or rapid removal standard forms. What exactly is your thought about that?
I think standard form agreements really embody commercial custom, don't they? Standard form agreements, they kind of share circular relationship with norm creation from top-down sources. Because often new norms are created from the bottom up, which then find themselves being interpreted by courts, and then they become hardened norms which get applied from the top down. So by using green terms in some of these standard form agreements, I think the recycled one is probably the best example. I don't think salvage forms go that far yet. The NYPE form makes some scope for slow steaming, which is a step in the right direction. But what I mean is if we start to see terms being used that say, you know, certain action is justifiable if for the purposes of the marine environment, if we start to see values like this being inserted into these standard form agreements, we know that environmental principles do play a role in salvage contracts, in the standard forms that govern salvage. So that's what I mean, that we can start with standard forms and see these principles develop from a standard form perspective. Does that make sense? Okay.